But I think it's appropriate that we actually begin our session today by remembering a human rights activist who passed away on Tuesday, Charles Roach. Many of us worked over the years with Charles on many issues, and he's a hero and a champion, and a man who deeply understood that human rights are meant to be exercised and practiced and to wrestle with in the public arena, and he certainly did his share of wrestling. And Toronto and Ontario and Canada are better because of Charles Roach and his legacy. And so I'd like to just take a moment to remember Charles Roach and the great human rights contribution that he's made to our city and our province and our country. I also, by way of introducing, I have a little bit of a mania. I think that this fellow who's on the screen now, Charles Peter Humphrey, should be at the top of everybody's mind as one of the greatest Canadian heroes. Unfortunately, in years of presentations, when I was as recently as yesterday speaking to graduate students in public health, I asked who's heard of John Peters Humphreys, and nobody had heard of him. And it's stunning to me, and I want to just begin our session again by not only celebrating the heroism and work of Charles Roach, but of John Peters Humphreys. He was a law professor at McGill University in the 1930s and early 1940s, and towards the end of the Second World War, as the civilized nations of the world were gathering in San Francisco to talk about a world of peace and a world of justice, a world in which the dignity of individuals would be recognized instead of wholesale murder and genocide. And John Peters Humphreys was summoned from McGill University, from the academic world, to go to San Francisco to help draft the Universal Declaration of Human Rights, which is one of the first of the modern compilations of comprehensive set of rights. Since we're here in an Anglican church, just earlier this year, the Archbishop of Canterbury, the head of the Anglican Church, called the Universal Declaration of Human Rights the high watermark of human consciousness and human morality. I think that's a high tribute to John Peters Humphreys and the work that he did. I never had the good fortune to meet him in person. When I look at his picture, I think he looks like an academic, and I've heard a story that when he was asked by Eleanor Roosevelt, the wife of the U.S. President, to prepare the first draft of the Universal Declaration of Human Rights, that he returned with a document that, no offense to Tracy, the lawyers sometimes call briefs, which was several hundred pages long, and it was an excellent exposition of human rights. However, I understand that Eleanor Roosevelt basically said that this won't do, we have to have something that fits on one page, and said that the drafters back and produced what we now call the Universal Declaration of Human Rights. Article 25.1 of the Universal Declaration of Human Rights from 1947 says that everyone has a right to standard of living adequate for health and well-being of himself and his family, including food, clothing, and housing, and medical care, necessary social services, and the right to security in the event of unemployment, sickness, disability, widowhood, old age, and other lack of livelihood and circumstances beyond his control. So this was a very powerful declaration, but it still existed as a declaration and not as an international legal instrument. So a little while later, it was codified into an internationally recognized legal instrument called the International Covenant on Economic, Social, and Cultural Rights. And indeed, Article 11 reflects language very similar with one important addition. The states party to the present covenant, that basically means the countries which have signed the covenant, which includes Canada as a signatory, recognize the right of everyone to an adequate standard of living for himself and his family, including food, clothing, housing, and the continuous improvement. And I just want to say that there was not a lecture on human rights law. The notion of continuous improvement has been enshrined in international laws as the principle called non-retrogression, which means that once governments begin to take certain actions, they can't unilaterally step back and withdraw. We don't expect governments to do everything all at once, to realize every single right, but we do expect once they start doing something that they're not going to step backwards. So the notion of non-retrogression is one that will now turn it over to our conversation where we actually talk about how do we apply these grand principles developed by a Canadian, and nationalism is not always a good thing, but sometimes it's good for us to actually be proud of some of our fellow Canadians, and proud of in particular John Peters Humphreys, who's been called the father of the modern international human rights framework. Now talk about how these rather abstract international principles can come into play here in Ontario. So our first presenter will be Chief Commissioner Barbara Hall of the Ontario Human Rights Commission, who of course well known to many of us as an accomplished municipal politician, Mayor of Toronto, and now the Chief Commissioner of the Ontario Human Rights Commission.
Thank you, Michael. Hello, everyone. Isn't it a gorgeous day? We should almost be sitting out in the park. Just to add to John Peters Humphreys, he went to McGill, but is actually from New Brunswick. And if you go to Fredericton, there's a John Peters Humphreys Center, and they do, amongst other things, education in the schools. So kids from New Brunswick know John Peters Humphreys, and we have to figure out how to get kids right across the country as well as some of us older folks. Another thing about the International Declaration, I was recently in England at the Paralympics, which was amazing. Great Britain really did a fantastic job of making the Paralympics as important, as focused on as the other Olympics. When we got to London, there were signs that said, to the Olympians, thanks for the warm-up. But the opening ceremonies were amazing. Stephen Hawking was there on stage, and he provided a lot of the conversation, the theme of the games and whatever. And they had these huge scrolls coming down from the skies. And they were the International Declaration, the Universal Declaration of Human Rights. And so that was the basis of inclusion in each of us being who we are and being proud of who we are. So as somebody who works in the area of human rights who feels very passionate about it, it was really great to see how they made that central. Lots of us have come here to talk about housing over the years, our concerns about housing. Michael, I thought about you this morning when I heard the news about the fire on George Street. Thinking about the housing on George Street. Was it housing where people trapped? And the good news is, just before I came out here, hearing on the news that in fact tenants in the buildings that were affected got out, even their pets got out apparently. But 23 years ago, on December 23rd, when there was the fire at the Rupert Hotel at the corner of Parliament and Queen, 10 people were killed, and Michael was very engaged in the work to make rooming houses, boarding houses around the city more safer and healthier for the people who live there. This year marks the 50th anniversary of the Ontario Human Rights Code. And so at the Commission, we've been looking back at the 50 years of history. And from the very beginning, back in 1962, the code talked about human rights in housing. In fact, discrimination in housing was one of the motivators for the code, particularly from the Black community and the Jewish community, who frequently, when they looked to rent housing, saw actual signs or were directly told, we don't rent to you, whatever you happen to be. In Ontario, before the code, there were even included in deeds of land. So you could buy a house, and it said in the deed that you could not sell the house to various groups, Chinese, Jews, or other objectionable groups. That's what it said before the Human Rights Code. So 50 years ago, that started to change. Flash forward to this century, most people know, or they should know by now, that it's against the law to refuse housing to someone based on their religion or the color of their skin or for any other grounds of the Human Rights Code. They should know, but complaints continue to come into the human rights system. And looking at that, the persistence of the discrimination in housing. A number of years ago, we decided to take a closer look at human rights and housing. We started talking to people across Ontario, and in July 2008, we released a report, Right at Home, report on the consultation on human rights and rental housing in Ontario. And Right at Home focused on housing as a human right and sets out a framework for collective action to identify, remove, and prevent discrimination in rental housing. We hear a lot about reports on issues. I think it's significant that the Commission in Ontario was the very first in Canada to look beyond the relationship of human rights and housing, beyond people being told or feeling that they were denied housing because of a ground protected under the code. We heard how tenants are affected by issues like adult-only buildings, discriminatory attitudes and stereotypes based on age, either too young or too old, and applicant screening requirements, including illegal rent deposits or requests for guarantors for some tenants only. Many tenants, housing providers, and decision makers also spoke about the challenges arising from the duty to accommodate because of disability or family status. This consultation report also looked at Canada's international obligations related to housing. As a signatory to the UN International Covenant on Economic, Social, and Cultural Rights, Canada has long recognized, through signing the document, that adequate housing is a fundamental right in our society. However, as we'll hear more about later today, and I think as we all know, the federal government has not necessarily acted on its international obligations. But even without a national housing strategy in place, local governments, housing providers, and advocacy advocates. It also set out some things that we at the Commission committed to doing ourselves. And I'm going to talk a little bit about some of the things that we've done since then. Firstly, we developed and produced a policy on human rights and rental housing. And a lot of people, including me at times, when we hear people say we created a policy, sort of glaze over. But this policy, for people who believe in human rights and housing, is important, not just in Ontario, but across the country. And what the policy does is fill in the gaps in the words. The law, the Human Rights Code says you can't discriminate in rental housing based on all these things. Age, race, religion, family status, sexual orientation, 16 grounds. And basically, that's all it says. And so the policy is our best advice as to how to use those words to deal with, one, discrimination, but also to advance the availability of affordable housing for all people. We will have a chance for discussion and questions later. So that's what our policy did. It went into the details of what those rights and responsibilities are for tenants and for housing providers. It provides the details for identifying, dealing with, and preventing discrimination in rental housing in Ontario. The policy provides details and guidance on many key housing issues. Issues like discrimination in neighborhoods in opposition to certain kinds of housing. Information on tenant screening and selection of tenants. What questions can landlords ask and what can't they ask? How to identify and change tenancy rules and policies that may be discriminatory, and the duty to accommodate, which applies in housing just as it applies in employment and services. In the report, we made commitments to look at provincial and municipal planning issues and to work with the province and municipalities to change bylaws, rules, and regulations that have the potential or do discriminate. We also made a commitment to use the tools we have, including public education, advocacy, and in some cases legal intervention to remove barriers to housing and prevent discrimination from happening in the first place. One of the ways we're doing that is through a guide we've published called In the Zone. I think there may be copies of it over there or information on how we get it. It's a guide that offers our best advice for connecting human rights with municipal planning and zoning. Some of this is things that people have been raising, talking about, questioning for a number of years, but it's the first time that a Human Rights Commission has come out advocating, approaching housing through those vehicles. We're actively taking communities across Ontario and having many conversations with municipalities, with planners, with developers, with housing advocacy groups on how we can change in 2012 to meet the legitimate needs of Ontarians. The guide in the zone provides some tools to help municipalities do this. And we want it to be a practical tool for a lot of folks involved in housing: planners, counselors, housing service managers, district social service boards, and other people who play a role in making decisions about planning and zoning for housing. It offers an overview of the human rights responsibilities of municipalities in housing. Included in that guide are a number of things. One is the legal obligation of municipalities to take steps to overcome NIMBYism, discriminatory opposition to affordable housing. It talks about their responsibility to focus on legitimate land use issues and not people zone. In other words, don't use zoning to keep people out of neighborhoods. Making sure public meetings focus on planning issues, not the people who will live in the housing, and not using mechanisms like minimum separation distances to limit housing options for people in communities protected under code grounds. The guide includes best practices to show the steps some municipalities have taken to overcome community opposition and to build inclusive communities. So we've put out the guide, we're working with municipalities, but we're also getting involved in cases at the tribunal, at the OMB, and in other forums, because other groups are taking on these issues. So I know there's some folks here involved with the DREAM team today. The DREAM team, together with the Human Rights Legal Support Center, filed an application or a complaint at the Human Rights Tribunal of Ontario. Complaints against Toronto, Smith Falls, and Kitchener, dealing with minimum separation distances between certain kinds of supportive housing. And we've intervened with them in those cases. The Toronto case is pending while the other two cases are in the mediation stage. I think in Kitchener, quite recently, Kitchener City Council voted to remove the separation distances for most group homes from their zoning bylaws and to allow them in all residential zones. So progress is being made. We're also involved in a case in the city of Hamilton related to the human rights implications of denying a group home zoning application by a group called Linwood Charlton, who provide housing for 8 teenage girls with mental health issues. At the moment, with the decision from Hamilton Council, it'll be impossible for Linwood Charlton to continue to house those 8 young women. Just before I came out to come over here, a staff person came rushing to my office and said, "I'm glad I caught you because we just filed our notice that we're seeking to intervene in this case at the Ontario Municipal Board. And there'll be a pre-hearing conference on October 16th, next Tuesday. Interestingly, in Hamilton, that case, while council has voted against the housing, public opinion is quite strongly critical of them for doing that. It's a case that's getting a lot of attention in Hamilton, and we're hoping we'll be successful in that. We're also involved in a zoning case at the Human Rights Tribunal involving residents of a group home in Napanee. In that community, against the advice of its lawyer, the town council unanimously denied the group home a zoning compliance letter, and its residents, people with developmental disabilities, have been repeatedly harassed and taunted by neighbors. One recurring theme we see in most of these cases is the disproportionate level of scrutiny the people living in supportive housing in group homes face compared to everyone else living in the neighborhood, particularly when it's housing for people with mental health issues. In the Linwood Charlton case in Hamilton, again, I remind you, 8 young women. Municipal councilors asked for police reports. Similar requests are not made for most forms of housing when they're seeking to get support in communities. And this was one of the many issues that we reported on last week when we launched Minds That Matter, our recent report on human rights, mental health, and addictions. And that report shares from a variety of perspectives the ways that municipal zoning and other practices can be barriers for people living with mental health issues or addictions. That report includes an entire section on housing with a set of recommendations for governments and municipalities, and also commitments from us. And one of those commitments being to advance human rights for people with mental health issues or addictions, and big interrelationship between these things. Many of the recommendations in the housing report are very similar to the ones we're making in the report on human rights and mental health and addictions. And we know that people with mental health and addictions issues are the most discriminated against of any group under the code. In other areas, landlords know that it's against the code or against the law to discriminate on, for example, the basis of race or age. And they hide it, so they will often go about things in a way that may be difficult to prove. In terms of mental illness, they often just say it right out. They're not aware of the rights of people with mental health and addictions issues or of their legal responsibilities in relation to those rights. Another area that we're looking at as part of the rental housing work is how some municipalities are using licensing to control or eliminate housing. And we're seeing this particularly in communities that have new or expanding post-secondary education institutes. So communities perhaps that haven't traditionally had student housing, suddenly an increased number. And because we're raising issues with them, that to just introduce licensing in one area to deal with what they see as issues related to students is people zoning, and they can't do it. And so they're applying licensing regimes throughout the whole community. And we know that that limits affordable housing for all people who want to live or must live, because those are their only options in congregate living, in boarding, rooming houses, that kind of thing. So in a couple of communities in North Bay and in Waterloo, we've done public inquiries over the summer looking at the impact of licensing bylaws on groups protected under the code. And we'll be reporting publicly very soon on what we found in those inquiries. So we know that rental housing licensing can be useful in some ways, particularly in terms of promoting safety and security of tenants. We're concerned that it can also be used to reduce or eliminate affordable housing options, and we're going to continue to be active in those areas. So we are out there raising the issues of human rights in planning and zoning. And I think it's fair to say that initially we were met with a lot of, what are you doing here? Like, we've been doing this stuff for a long time, and human rights aren't a part of it. This is, we're planning and building and zoning and whatever the way we've always done it. Well, when in human rights, you hear we're doing something the way we've always done it. All red flags and horns and beepers start going off. And so through the things I told you about, interventions at the OMB, people say, the Human Rights Commission at the OMB? No. But the OMB is saying yes. They have said in decisions that these issues are important to be raised here, and they should be raised here. And then in terms of complaints or applications at the Human Rights Tribunal, municipalities are beginning to understand. We sent copies of In the Zone out to all municipalities across the province, and initially there wasn't a whole lot of interest. I think there was a sense that, here's the Human Rights Commission trying to create work for themselves. You know, that's often what we get when we work in areas where traditionally people's human rights haven't been respected or protected. But now municipalities are sitting up. And the good news is we're hearing from many of them. They're contacting us and saying, we want to deal with this issue. We're developing new bylaws. Will people from the commission come and meet with our staff, and so that we can understand where the issues are, and that what we do will comply with the code. And that's important, that people understand that they understand that the Human Rights Code is what lawyers call quasi-constitutional. That means in Ontario, the Human Rights Code applies to all other laws unless the law specifically Human Rights Code applies, and if that legislation doesn't comply with the code, then it can't be applied. So we're taking the message that the protections of the code need to be part of the discussion and the process in doing anything under the Planning Act and the Municipal Act. Good planning involves creating healthy, vibrant, inclusive communities, and human rights are an important part of that. And we're going to keep working until all of the municipalities across Ontario get it right. But that's a big job, and that's one of the reasons we're intervening in cases or initiating complaints, is to get a solid group of cases, of case law, of decisions to take out to municipalities so that they understand that if they don't comply, they can end up before the Human Rights Tribunal or in trouble at the OMB or in other forums. So I'm glad that I'm here today talking about housing, as I've done on many occasions, wearing lots of hats. I'm glad that I'm here wearing the Ontario Human Rights Commission hat. We don't have any magic wands at the Commission, but I think we do have a new set of tools, or tools that we're starting to use, that support and build on the work that all of you here have been doing for many, many years. We understand what the Universal Declaration says, what it says about the right to housing. But we know that having words written in documents like that is important. As a vision, it doesn't guarantee the rights. The question is how to take those rights off the page and make them a lived reality for people in Ontario who today in 2012 still don't have safe housing to live in. So we're glad to be part of the struggle with you. And I thank Michael and Wellesley Institute for bringing us together and inviting us to be part of the discussion. Thank you.
Chief Commissioner Hall. We will have a chance to engage in a conversation with Chief Commissioner Hall after our next presenter. I just wanted to say one thing, of many things that we want to thank Chief Commissioner Hall for, when she said that the Ontario Human Rights Code applies everywhere except those few areas where it's specifically exempt. It does apply across the street at Toronto City Hall, and Chief Commissioner Hall did write to Mayor Ford at the beginning of this year to remind Mayor Ford in the most polite and respectful language that the city's plans in those days to sell off a large amount of Toronto community housing could well bring up human rights issues, and the mayor needed to consider the human rights implications. So we think taking human rights and applying them in the important issues of the day is very, very important. And of course, this is where Tracy Heffernan, who is a well-known human rights lawyer with the Advocacy Center for Tenants, Ontario, will now take us in terms of the work she's doing with the Human Rights Legal Challenge. And as Tracy's coming up, I'm just going to get a presentation on that. It'll just take a second to get the projector warmed up.
Hi everyone, and thanks for coming. I'm going to talk about a campaign to have the right to housing recognized in Canada. And part of that campaign involves a charter challenge. This is something that we've been working on at the Advocacy Centre for Tenants, Ontario, but it has been in coalition with many, many community organizations, with academics, and with lawyers. And everyone has contributed to the process of both thinking through what this charter challenge would look like and also how we should bring this campaign forward. So the interesting thing is, in Canada we used to recognize the right to housing. So this was the equivalent of the federal Minister of Housing today. And here he is talking about good housing at a reasonable cost. It's a social right of every citizen. Not only that, he went on from there. He talked about how when you speak about housing, it's not just the bricks and mortar. It's actually a home. It's a community. It's a place where people can develop to their full potential. So in the 70s and the 80s, what we saw was money put into affordable housing. And there was a lot of housing that was built. Some of the co-ops that exist today in Toronto, for instance, subsidies were provided to low-income and moderate-income families. Unfortunately, that changed fairly rapidly. So what you see on this graph, which Michael prepared, is for 10 years between 1978 and 1988, there was considerable investment in affordable housing in Canada. But we see a significant drop starting in about 1990, and by 1994 it's actually a plummet from which we haven't recovered today. But compare that to overall housing starts in Canada, where what we see is a steady increase from about 1995 onwards, and the graph goes steadily upwards with a little dip in 2008, but nothing like what we've seen with affordable housing. So it got to the point where Shapcott, who was the UN Special Rapporteur for Housing, he came to Canada and he traveled through the whole country. And he met with community organizations, he met with government officials, he met with many individuals, and he talked to them about what was going on with regard to housing. Shapcatt's conclusion was that what we are looking at in Canada is actually an emergency. It's a national emergency. He was shocked by the fact that in a country as wealthy as Canada, that he was seeing people who were both homeless and precariously housed throughout the country. One of the things that he commented on was how for Aboriginal women in Canada, they were the ones who singularly had the worst housing of any group. He said it didn't matter where they were living. They could be living in the north of Canada, the south, in rural or urban. They were singularly the least well housed. Okay, so time for a little somewhat dark comic relief. There's been a lot of discussion about austerity. You know, we're probably all thinking if we never hear that word again, we'd be quite happy. So if you look at it, what's austerity? So austere, what does that mean? It means lack of comfort, lack of adornment, lack of luxury. But when you look at what's going on, so I'm going to take both Ontario and Canada as an example. When we actually look at what's going on, we really have to pose the question, austerity for whom? So starting with the minimum wage in Ontario, So the Liberal government did a good thing. That the minimum wage had stagnated for a long time, and they decided to change that. So over the course of 4 years, up until 2011, they made incremental changes. So we're now at $10.25 per hour, and that's certainly much better than it was several years ago. The problem with the current minimum wage, however, is that if you work full-time, full year, so 40 hours a week for the year, you're actually going to make less than the low-income cutoff. So what's the low-income cutoff? The federal government says we don't have any measure of poverty in Canada, but many researchers and activists use the low-income cutoff as a way of looking at what does someone actually need in order to survive? So what our federal government has said is that if you are a single person living in an urban area, you need a minimum of $22,000 a year in order to meet all of your basic needs, so food, rent, transportation, and so on. But if you are working for minimum wage, you're actually making less than that. So you're falling below the poverty level. There's a lot of talk about children living in poverty, but when you actually look at who those children are, 1/3 have parents who are working full-time, full year. Because if this is for a single person, once you add a child into that mix of the 21,000, you're falling even further below the poverty line at that point. Employment insurance, all right, now this is one that really annoys me. So if you look at 1990, 80% of people who applied for employment insurance actually received, of the people who applied for employment insurance, 80% actually received it. But the government made significant changes to the Employment Insurance Act starting in 1996. So what do we see now? In Ontario, of all the people who apply, only 26% are actually found eligible for employment insurance. And in Toronto, that figure is 22%. So what that means is that people who are working and paying into employment insurance, the idea, of course, is that if you lose your job, you will have a bit of a stopgap until you find another job. But in fact, in Toronto, only 22% are actually being found eligible. Meanwhile, because people who are working are paying into this fund, the federal government's got an enormous surplus. It makes my blood pressure rise every time I look, so I have not looked recently. But the last time I looked, it was $57 billion. A number of unions decided that they would challenge the federal government on this, so they took them to court, and in 2008, the case was at the Supreme Court, and the union's position was, if people are paying into this fund for employment insurance, they should be able to get employment insurance, because otherwise what you're looking at is a further tax, particularly on low-income people. And the Supreme Court basically said, well, too bad, so sad. So what the federal government has done is use that $57 billion to pay down our deficit. Then if we look at rent, what we know is that 36% of tenants living in Ontario live in poverty. But nonetheless, in 1998, the government decided that it would be a good idea to get rid of rent control. So we had rent control in Ontario for many years prior to that. And what this meant was that when you went to rent a new apartment, the landlord could charge you as much as they could possibly get for that apartment. Prior to that, the landlord could only charge you what the previous tenant had paid. So this led to a number of problems. One of the problems was particularly in Toronto, but also in other communities across Ontario, we saw an enormous increase in high-priced housing, because what was happening is the landlords wanted to get rid of those tenants who were paying the rent-controlled rent so that they could bring it to the so-called market rent. So in Toronto, what we've seen is a gentrification of many, many neighborhoods, and people being pushed into the outer suburbs who are low income and where they have fewer resources, poor transportation, and so on. So the ones who can least afford it. To add insult to injury, this year the Ontario government decided that as part of the austerity, so again, if you keep that question in mind of austerity for whom, they decided that they should cut the community startup benefit. So the community startup benefit is something that people have used who are on disability or on Ontario Works in order to pay their first and last month's rent. Or if they had bed bugs and they needed to replace their furniture and so on, they could go to their worker and they could ask for community startup. It was limited. They could only ask for it every 24 months. If they were being evicted because they were in arrears, they could go to their worker and ask their worker to pay off the arrears that they could stay in their home. But the Ontario government has decided to cut that. They've cut it by 50%, and they've tossed it in with a lot of other programs, including the rent bank, and have told municipalities that they're going to have to figure out what their priorities are going to be. Then we've got the comparison of rent to shelter allowance. So if you look at this graph, what you're looking at here is the blue bars represent rent, and the red line represents the shelter allowance paid to, in this case, we're looking at Ontario Works. So we're looking at what is paid to a single parent with 2 children looking for a 2-bedroom apartment. And in 1994, the average rent for a 2-bedroom apartment was $784. The shelter allowance was $634. So there was still a gap between what people were receiving for shelter allowance and what they were actually going to pay, but it was only $77. So now we fast forward to 2011, and the average rent is $1,149 for a 2-bedroom apartment. The shelter allowance has gone up by less than $100, so it's at $707. So the difference, in 1994 it was $77, it's now $442. And in the meantime, I'm sure that many people have heard this stat before, but we've seen an exponential growth in the salaries of CEOs. So in 1980, it was 25 times what the average person made, and in 2011, it's 250 times.
How can we stop the pigs?
So what are we going to do about this? Well, one thing that we've done as the Right to Housing Coalition is thought through Right to Housing campaign. One of the first things that we looked at were all of these agreements that Canada has signed, and all of them say that, and this is from 1948 on, the Convention on the Rights of Persons with Disabilities was signed about 2 years ago. All of them guarantee the right to adequate housing.
No thanks to you.
We also have the Canadian Charter of Rights and Freedoms. So there's Section 7. Section 7 says everyone in Canada has the right to life, liberty, and security of the person. And Section 15 says you also have the right to live and not be discriminated against. One of the former Supreme Court Justices, Louise Arbour, who's gone on to do many other things, And about 10 years ago, she gave a speech and she was talking about how the courts have been so timid in terms of recognizing social and economic rights, like the right to housing or the right to an adequate income in Canada. But she also talked about the timidity of lawyers in terms of bringing these cases forward. So we decided that we would bring this case forward. What we're going to say, what we have said so far to the court is this. The provincial and federal governments are currently in violation. They're in violation of the law because they aren't respecting those international agreements and they aren't respecting our domestic laws, so the Canadian Charter of Rights and Freedoms. We're saying that this crisis of homelessness and inadequate housing leads to a situation where people do not experience security of the person or and we also, when we look at it, we see that we're using Section 15 because when you look at who's impacted by the lack of adequate housing, you see that some groups are affected more than others. So I talked earlier about Aboriginal women. It's Aboriginal women, it's racialized communities, it's people with physical disabilities, it's people with mental health issues. All of these people are impacted in a way that others are not in Canada. So what we're asking for is that the courts say to the provincial and federal governments, you need to adopt a national housing strategy. You need to take ownership of this issue. You need to address it. You need to do that in consultation with groups across Canada and develop that strategy that will address the crisis of homelessness and inadequate housing in a way that will actually be effective. And you need to implement a plan so that all Canadians have adequate housing. So one thing to be clear about is that we're not asking for the right to shelter. We're asking for the right to adequate housing, housing that's affordable, that provides enough room for people to live in, that is in a good state of repair. In New York City, they asked in the 1970s for the right to shelter, and that's what they got. They got a lot of shelters. They didn't get a lot of housing. So how has the government responded to our case? They brought a motion to strike. So what they've said in their motion to strike is, well, essentially they're saying you don't have a hope in hell, but they put it in legal terms, things like you don't have a reasonable cause of action, there's no legal right to housing in Canada under the law, and this is plain and obvious. This motion will be heard in May 2013. But here, for me, the biggest irony is that homelessness actually costs more than housing. So I don't fully understand why the government would choose to bring a motion to strike. In Alberta, which is not known as the most radical of provinces, politically speaking, several years ago, they actually did a study to look at the costs of homelessness. And what they found is that homelessness costs double what it costs to actually house people adequately, even if people need support. So if someone has a physical disability and they need assistance with shopping or have other needs in their home, even when you add in the cost of those supports, it's half the amount. And the reason for this is because then you don't have people in shelters, which cost almost $2,000 a month. You don't have people going to jail, which costs over $4,000 a month. You don't have people lingering in the hospital because they have nowhere else to go, which costs almost $11,000 a month. Just compare that to the actual cost of housing, and you see that if you give someone a rent supplement, it's about $770 per month. If you actually house them in social housing, it's about $200 a month compared to these other costs. So what I said when I started was that this is more than a court case, it's actually a campaign. And so the groups who came together to start thinking about how to bring this case a few years ago have formed a Right to Housing Coalition. And the Right to Housing Coalition has been very active in terms of providing workshops, organizing demonstrations, trying to spark the public imagination to think differently about this. I sometimes think that one of the biggest liabilities for Canada is that our neighbor is the United States. So we're always comparing ourselves to the United States and feeling pretty good about what we do in Canada. But if we actually compare ourselves to Europe, we might think differently about our social programs, particularly around the issue of housing. So in Scotland, where they have perhaps the most well-developed right to housing, they started in the 1980s to organize. It was a whole series of things that they did. They organized, they protested, they brought court cases, they pushed for legislative change. And in 2012, everyone now has the right to housing in Scotland. And if you're homeless and your municipality is refusing to house you, you can actually take them to a tribunal and sue them for that. In 2007, in France, there was an election coming up, and activists in France decided they would put up these red tents, which you're looking at on the screen. They put it up along a canal in Paris, and they invited Parisians to come out and sleep in the tents in solidarity with people who were homeless. As a result of those actions, France actually adopted the right to housing as well, modeled on what they have in Scotland. Now, what's interesting in France is that there's been really weak implementation of that. And so that goes back to why I think you can't just have a court case. Actually, you have to have a campaign. You have to have people supporting things. Even if you win in court, you need people who are going to ensure that the law is implemented. In South Africa and Finland, the right to housing is actually recognized in the Constitution. There's a Portuguese author by the name of Saramago, and he talks about how when you have charity is what you have when you have no kindness or justice left. And I think that's something that we really need to think about with regard to the right to adequate housing and the right to adequate standard of living in Canada. Are we going to have kindness and justice, or are we going to have charity? So clearly, as you can see, Canada hasn't had the best record over the last 4 years in terms of housing, but we did at one point, and so that's kind of hopeful. The courts, as I said earlier, have been timid about recognizing social and economic rights, but we can force that issue. We shouldn't be timid about trying to do that. Because really, quite simply, it's time for this situation to change, and I think we can do that. So I just want to point out, oops, I forgot to give you that slide. That was one of our demonstrations that we held last year. But here are all the individuals and organizations that have contributed significant amounts of time and energy and brilliance in building this case and building this campaign.
Thank you, Tracy. Just slip back to the... So we've heard from Chief Commissioner Hall about how international housing rights are being brought to bear for the work of the Commission and with municipalities across the province. We've heard how the Right to Housing Coalition is bringing the courts into play. And I just wanted to mention two other went the wrong way. Nations Human Rights Council is the highest human rights body within the UN system. It meets in Geneva, and every civilized country in the world is part of the UN Human Rights Council. It used to be the United States was a holdout, but under President Obama, they actually finally joined the Human Rights Council, which we were very pleased about. Canada has long been a member of the Human Rights Council in Geneva. There is not, unfortunately, an international police force on human rights, nor is there an international jail to put governments who violate human rights, but there is the United Nations Human Rights Council. And a few years ago, they adopted a new procedure the nickname is called naming and shaming. It's a procedure to ensure that countries begin to respect human rights and not violate the human rights of the residents of their countries. And Canada came in front of the United Nations Human Rights Council in 2009 for its first Universal Periodic Review. Many organizations, non-governmental organizations, presented evidence to the Human Rights Council about the systemic violation of the right to housing and other fundamental human rights. And the Human Rights Council, and you've already been introduced to Wellesley, the United Nations Special Rapporteur of the Right to Adequate Housing. He also prepared a detailed report to the Human Rights Council, which was tabled in the same session based on his fact-finding mission to Canada in the fall of 2007. And he actually was in this very room, meeting with some of you. Chief Commissioner Hall was here as well, and was across the country. So all that fed into the UN process of 2009, and Tracy already quoted from some of his report. He did note that Canada has a successful history in terms of housing issues, and there's lots of very smart people that know what needs to be done, including people in this very room. But then he knows there's been a significant erosion of housing rights. I said at the very beginning that there's a principle in international human rights law known as non-retrogression or progressive realization of human rights. And Canada stands guilty not only of violating fundamental rights, but of actually going backwards, of having rights that previously were realized having been eroded. And that was noted by the United Nations Special Rapporteur. So all this came together in 2009. And the Human Rights Council issued 68 recommendations to Canada. The process in the UN is very polite and diplomatic. Nobody raises their voice or shouts at each other. They all speak very nicely. But 68 very pointed recommendations on specific human rights violations, and 3 of them concerned housing issues. The United Nations noted Canada has violated international housing rights standards in significant ways. And the process of the United Nations after a United Nations Universal Periodic Review is the country then has a chance to stand up and basically explain itself. And Canada actually stood up in June of 2009, so a couple of months after the Universal Periodic Review, and in the polite words of the UN, it took on board the 3 recommendations on housing. And we were, of course, I may say so in a non-partisan way, somewhat surprised that our federal government would actually accept the criticism of the UN when it did. And the specific language, it said, yes, we have to do better on housing issues. We agree that we haven't done as good a job. We promise to work better with the provinces and territories in terms of a comprehensive national housing plan. And they did point to the 2009 federal budget, which brought $2 billion in additional funding for affordable housing as an example of the renewed commitment of the federal government. So the federal government in 2009 gave some very brave words and some firm commitments. Canada is back in front of the UN Human Rights Council next February, in February of 2013, and it will be reviewed again. And specifically, what the United Nations will be asking Canada is, how have you done in terms of those commitments you made? What have you been doing in terms of your commitment to work more closely with the provinces and territories? What have you done in terms of your commitments around dealing with housing rights violations and the erosion of housing rights? And the Wellesley Institute has produced a brief. There's a copy of it over there. I apologize to my colleagues from the Wellesley Institute, our communication specialists. It's one of the most boring pieces of paper you'll ever look at. It's tiny little type of little numbered paragraphs, but that's the way the United Nations insists that everything be formatted and presented. But you'll see copies of it there, and you'll see that what we've done is taken each of the commitments that Canada made in federal program. It's called the Federal Affordable Housing Initiative, and they stood in Geneva and said, we're very proud of this program. In 2009, they said, this is an example of our commitment to Canadians. In 2009, about $600 million was committed to that program, which was not enough, but it was certainly a handsome amount of money compared to previous years. But that funding has been cut and cut. There was a 97% cut in funding in 1 year alone, in the year 2011. And by 2016, the federal government says there'll be no dollars committed to affordable housing initiatives. So our report to the United Nations Human Rights Council on the issue of Canada's compliance with its commitments is that Canada has failed to meet the commitments that the federal government stood in Geneva and made. On its commitment in terms of collaboration with the provinces and territories, in the years leading up to 2009, the federal government met on average once or twice a year in a federal, provincial, territorial housing ministers conference. In the years from 2009 to the present, 2012, there have been 276 federal, provincial, territorial conferences on everything from sports and recreation to health to taxation. There was one meeting in 2010, 2 meetings in 2009, and no meetings in 2011 or 12. So the federal government has failed as a commitment for collaboration. So we'll be taking to Geneva that message. I also wanted to say to you that in a couple of weeks in our national parliament, there'll be a parliamentary debate, which I'm sorry to say, I can safely predict will not get any media coverage, but it's one of the more important parliamentary debates because Bill C-400, which is national legislation to achieve exactly what Tracy set out in the Right to Housing Challenge, legislation that would compel the federal government to work with provinces, territories, municipalities, Aboriginal groups, community organizations, non-profit groups, and the private sector to create a new national housing plan and to implement that plan with adequate funding. That legislation is due for second reading debate on the 17th of October. We're very confident that 3 of the 4 political parties in the House of Commons will support it. Sadly, the government